Hello guys, so we need to start from post independence, right? I left here. We were doing unit 5. After India's independence in 1947, efforts were made to develop a uniform civil code for dealing with matters of personal law. It started with the Uniform Hindu Code Bill, which attempted to combine the varied regional customs and usages. So, when India got independent, now there were different religions. India became a land of diversities. So, different religion, different laws for their personal or civil matters. That's why it was a practice or effort that we combine all those religions और civil matters ताकि जो भी मैरिज या डिवोर्स एक्सेट्रा चीज़ें हैं सक्सेशन है उसमें एक ही लॉ हो irrespective of person belonging to which religion or community. Like other criminal matters have the same law, IPC, CRPC, constitution, which applies uniformly over every citizen of India. Right? So first of all came the Hindu Code Bill, which attempted to combine varied regional customs and usages. So whatever customs were there, what would be written in the Hindu Code Bill? What is prevalent today? That will be codified and written over there. So that whatever was earlier non-written or not reduced to a written form is now reduced, so that when other person asks okay, on what basis you are practicing this, you would be referring to that Hindu law says this or Hindu custom says this, which is written in this section of this law. Right? Law works on लिखा कहाँ है, ठीक है. सो उस चीज़ को written form में reduce किया हिंदू कोड बिल में. whatever customs or traditions or usages were prevalent at that time among the various communities of Hindu religion, उसको combine किया. That's why it is Uniform Hindu Code Bill. 1951 shelved due to opposition, but there was opposition that no, you no need to combine it, or maybe there were objections, or some other practices had to be included, or some differentiation was done for a community. There was opposition, so it could not pass. Since constitution had adopted the word secular as an important feature of Indian Republic, uniform family law was seen as biased in favor of Hindu majority community and unsecular. Since preamble and constitution had secular word written, which means that there will be no official religion, so when the Hindu Code Bill was adopted or when it was made, the main opposition was that you are being biased towards that religion. If you are making a uniform family law for Hindu only, that means you are being biased for that. So make it for everybody, right? In a similar manner, in 1955, Parliament adopted and codified 4 different major legislations governing family and personal law matters of Hindu community: HMA, HSA, HMGA, and HAMA, which is Hindu Adoptions and Maintenance Act. So around 1955 to 56, all major legislations, all Hindu personal law matters were codified and they were framed in different acts. पहले क्या था, कोड में ही ये सारी चीज़ें रहती जो हिंदू यूनिफॉर्म कोड बनाया. बट now for different matters, for marriage we had a different act, for succession we had a different act. So that was the way in which Hindu law, Hindu personal law was codified. Christian, Parsis, Sikhs have their own codified marriage acts. Muslims governed by Sharia. Muslim law is not codified, and traditional communities continue to practice their uncodified customary laws. In Article 44 provides for a goal or aspiration for uniform civil code. This has never been taken up seriously for the fear of communal violence, which is true for today even. Human rights and gender perspective. There are various provisions in constitution that are specified for gender equality. Why do we need provisions for gender equality? When something is absent or when there is a loophole regarding something, it is not adequate, then only we need law to work on that. We need a legislation on that point, right? So if there is gender inequality, or if there is a subordinate status to women, or they are not much empowered, that's why we have made special acts or special provisions for them, so that their vulnerability in the society can reduce, and they may also reach the equal status as their male counterparts, right? So if there is gender inequality, then only we have the provisions for gender equality. Now males are always at a prejudice that why special status is given to women, why special laws for women, because they need that protection. Had you not treated them unequally, had you not done tortures or harassment on them, those special laws would not have been made. Though over here I am not denying the fact that there is a misuse, a great misuse and harassment. Harassment can be done on anybody irrespective of gender. But because of the widespread torture or discrimination against women, there was a need to enact special laws. That's why we have them, to ensure the equality which was not there earlier. So to remove those shackles only, the laws were made, because the status was not adequate. The preamble resolves to secure justice, liberty, equality, dignity of all. Justice means to provide better opportunity or jobs or better living conditions to all. That is also dignity, right? To maintain their bodily dignity as a human. Liberty means freedom. Equality, to treat everybody equal. Article 14, equal treatment before the law for every person. 15, prohibits discrimination based on certain grounds. So idea of equality is strongly emphasized. Exceptions exist. 25, 26 provide for freedom of religion, that includes freedom of conscience and free profession, practice, propagation of religion, and freedom to manage religious affairs. So freedom of conscience means person can follow what his belief is, what he believes in. Okay, there is a difference between two terms, belief and believes in, right? तो जो भी मेरी conscience means अंतरात्मा, whatever my persona says, or my set of values with which my upbringing has been, I am free to practice that. So that is conscience. Profession, everybody knows, and practice and propagate religion. Practice means to follow it, propagate means to spread it, so that more and more people get to know what its values are or what the traditions are, and they may also accept my religion or respect my religion, right? And freedom to manage religious affairs, like every religion has its temple or place of worship, or it may also open some educational institutions, and in which there will be some seats reserved for the students practicing that particular religion only, because that institution was made for advancement of that religion or to propagate it. Okay, like Christian schools or missionaries which are prevalent even today, they have certain percentage of seats reserved for Christian students only, because it is a minority, and to uplift that, or to be into the mainstream, it has made those institutions with reservation for its religion people. The religious communities have used these provisions to argue that modifying their family laws would be interfering with their freedom of religion. That's the basic point of argument against implementing UCC, that is Uniform Civil Code. Because if I say that why four marriages of limited polygamy to be allowed in Muslims, when for Hindus and Christians we have only one marriages? So it should be uniform for all, one marriage, every person irrespective of the religion to which he belongs, right? But that would be against the freedom of religion guaranteed by these articles 25 and 26, according to which they have the right of limited polygamy, right? So that is the basic contrast or conflict between the two. And article 44 is a DPSP, whereas article 25 is a fundamental right. So you know what will prevail. Due to this tussle only, we have not yet achieved that goal of UCC, which was an aspiration of constitution framers. That's why it was put in DPSP. I hope you know what is the basic meaning of DPSP or why they were formulated. Okay. For those who promote traditional religious values, the above gender equity provisions are contrary to their customary methods of law. Customary methods of law means their customs which, due to being practiced for a longer period of time continuously, have become or have taken the shape of law. Right? So whatever the traditional Hindu religious methods are, there are some gender stereotyping or gender roles that have been assigned. And suppose I give you an example. द पिंड दान सेरेमनी मीन्स जब डेथ हो जाती है तो कौन पिंड दान करता है, वो हमेशा सन करता है, बेटा करता है. सो दैट इज़ अ जेंडर रोल विच इज़ असाइंड. Now that would go against the gender equity provisions. Why? Because as per gender equity, you cannot assign something to a particular religion and disallow the daughter to perform that. You have to give equity or equality to both. So whatever a son can do, you have to give the same role to a daughter as well. But it is against the customs. So that was an example. Now let's see the example which is given. The traditional Hindu religious legal methods found in the laws of Manu provide for unequal treatment of law and punishment based on gender and caste. So there is an unequal treatment on grounds of gender or caste, and so the law which is applicable to them or the punishment which is given to them, it is different. Widow remarriage was not allowed. Widower remarriage was allowed. I hope you know the difference, right? Then a widow was required to practice sati, but a widower was not required to practice that, isn't it? So that is the unequal treatment of law or punishment for different genders. And then untouchability or lower caste, however they were treated, everybody knows that, for which upliftment we have the reservations in place currently. Gender inequalities also exist within Islamic legal traditions. This one example I give you, like in Islamic marriages which is called nikaha, we require witness to be present, to witness or to sign over there in that contract that I was the witness of this marriage which has been taken place. Okay, so male is considered to be equivalent to one witness, but wherein a female is sitting, she is equivalent to two males. That means if you are calling for a male witness, that will count as one, okay? But if a female is sitting as a witness, then she has to be counted as a half male. So for one witness to be there, you have to make sit two females so that they can be counted as one witness. समझ में आ रही है? This is the inequality. Just an example कि एक मेल को तो एक विटनेस आप ले लोगे, बट एक फीमेल को एक विटनेस आप नहीं लोगे, वहाँ पर दो फीमेल्स विल बी काउंटेड एज टुगेदर एज वन विटनेस. सो अदर एग्जाम्पल्स यू कैन सी. I hope I have said this correct, because I don't know much about Islam. Then The modern Hindu laws were adopted by reconfiguring traditional religious laws and further based on modern constitutional values. Complete gender equity has not yet achieved. It will not ever be achieved, what I think. So, modern Hindu family laws, HMA, HSA, which we saw the names earlier, they were adopted by reconfiguring, means recombining or rearranging the traditional religious laws and then combining it with the constitutional values, because they were made post constitution 1955 to 56, right? So we had the constitution in place that time. So what, in line with those constitutional values, the legislations were made so that again they may not go contrary to the basic principles of constitution or the basic structure, so as to declare them null and void or not to face opposition. Fine. But gender equity उसमें नहीं आई थी, which was a principle of constitution, though it was incorporated little bit, but that पिंडदान example which I told you, it is still written कि पिंडदान तो बेटा ही कर सकता है. He was only considered the co-partner of joint Hindu family. But 2005-2011 judgment said that daughters are also the co-partners. So that may be a part or a way to ensure gender equity for Hindu laws, but the complete equity has not yet been achieved. That's why we still, again I will say, we still have the special laws for women upliftment in the society. Instances of gender inequality existing in the present day Hindu family include HMA Section 5 prescribes marriageable age for girl as 18 and boy as 21. So this is an example where there is a different law for different genders. Marriageable age for girl is 18 and boy is 21. So that is a different law for them, right? Recently, the government has proposed marriageable age of girls also to be increased to 21 years. But it has not been incorporated yet, as far as I know. HSA provides different methods of interstate succession of property for male and female intestates. Now, one homework that I am giving you, you find out the sections for method of interstate succession of property of male and for female. Okay. Hindu Minority and Guardianship Act Section 6 prohibits a mother to act as a child's natural guardian unless the father is dead or otherwise disqualified. And Hama Section 6 prohibits a mother to give her child in adoption unless the father is dead or otherwise disqualified. So you see, mother cannot be the child's natural guardian, although she is giving birth to that child. But she is not the natural guardian of her child. The father is the natural guardian unless that father is dead. If the father is dead, then only mother will be considered as the natural guardian. Or if the child is illegitimate child of the father, okay, then mother would be considered as the natural guardian of that child. In that case, for illegitimate child, father is not the natural guardian. So these are the gender inequality provisions for the Hindu Acts. Some examples believed to promote gender inequities in Islamic family laws include practice of polygamy, common view that husband can divorce his wife by triple talaq, and a Muslim husband is to pay maintenance to a divorced wife only during iddat period. So these are the gender inequities. Only during 3 months husband would pay maintenance to the divorced wife, और बाकी उसकी ज़िंदगी का क्या, husband is not responsible for that. Okay. And common view that husband can divorce his wife just by pronouncing talaq 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 3 times, that is triple talaq, and they are divorced. But women does not have such right. So these are the gender inequities. And polygamy is permitted for a Muslim man but not for a Muslim woman. Other practical challenges in achieving gender inequity in the realm of family laws, one of the foremost being lack of information that are applicable to respective communities. Most residents of rural India know neither the minimum age of marriage nor that dowry is prohibited. Now, I tell you one thing, even if the educated people or elite class of the society, they know that dowry is prohibited, the person taking or giving dowry, both groups are punishable. Still, it is taken, and now the name has changed. Only the nomenclature has changed. Now they say we are giving gifts. It is not dowry. Okay, so that is the difference. In Islamic law, there are three types of divorce. Talaq-e-Asan, which is the most ideal way of dissolving a marriage. Talaq-e-Hasan, talaq is pronounced once a month over a period of 3 months. If cohabitation is not resumed during this period, divorce gets formalized after the third utterance in the third month. So there are 3 months. हर महीने आपको एक बार तलाक बोलना होता है. अगर पहले महीने में एक बार बोलने के बाद आपने कोहैबिटेशन रेज्यूम नहीं किया, मतलब आप साथ में फिर से रहने लगे एज हस्बैंड एंड वाइफ, if that doesn't happen, then the talaq is finalized and the couple is said to be separated or divorced. Talaq-e-biddat or instant triple talaq, which is now prohibited or banned in India, punishable, right? Instant talaq or triple talaq is an Islamic practice that allows men to divorce their wives immediately by uttering the word talaq 3 times. It can be oral, written, electronic means, SMS, email, किसी पर भी. अगर हमने 3 तलाक लिख दिया किसी मुस्लिम मैन ने to his wife, they are divorced even if they are not sitting one to one at that point of time. They may be in different cities or different countries whatsoever, but just a SMS with talaq, 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 and they are divorced. So this is the situation. And as you can see, allows men to divorce their wives. So it is not the other way around. So that is one again example of gender inequity. The practice of divorce by consecutive utterance of talaq, triple talaq, has been deemed invalid under the new law. Instant talaq in any form, spoken, written, by electronic means, email, SMS, etc., is illegal and void, with up to 3 years in jail for the husband. Now, why for the husband? Because husband is only having the right to give talaq. No, wives cannot give triple talaq. So whoever is doing the wrong, he will be punishable. The other 2 forms are valid under the Muslim law. So this is considered to be invalid, and this is also not only in India, but it is also considered to be against law in various Islamic countries. Find out in which Islamic countries it is also not practiced. And what is the name of the act by which this is declared to be illegal in India, or this punishment of 3 years is prescribed? Institutional framework, family courts, this I will be dealing in the next video. Thank you.